The Honorable, the Supreme Court.
Okay, thank you all very much. Please be seated. And please go with case.
Good morning, Your Honors. The matter before the court today is the case entitled Stanley Reynolds v. State of Vermont, case number 24 AP 040. Representing the appellant, the estate of Stanley Reynolds, is David Slay. Representing the appellee, State of Vermont, is Hannah Yindra.
Thank you, counsel. Come on up, please. For the record, introduce yourself and your client.
Thank you. Good morning, Your Honors. My name is David Slay. I represent the estate of Stanley Reynolds.
Thanks.
Stanley was accused of the crime of sexual assault. Prior to trial, he told his trial counsel that there were 4 credible witnesses who could testify convincingly that the relationship that he had with the accuser was ongoing and consensual, and that he thought that a reasonable jury, having heard those witnesses, would find him not guilty. His trial counsel didn't call any of the 4 witnesses, and Stanley was convicted. He appealed that conviction to this court, and the conviction was affirmed. Steadfastly maintaining his innocence, he filed a petition for post-conviction relief, alleging that his trial counsel had been ineffective in not calling those 4 witnesses. The trial court initially ruled against him, and he appealed to this court from the adverse decision on the post-conviction relief petition. This court first sent the case back to the trial court for reconsideration, particularly on the failure to call those witnesses at trial, and the trial court reversed its decision and vacated Stanley's conviction. Stanley maintained his innocence throughout the trial process, throughout the appeal process, throughout the post-conviction initially, throughout the post-conviction appeal, and at the rehearing of the post-conviction matters. And after his conviction was vacated, he filed a claim for compensation for over 8 years that he was incarcerated after that verdict.
So the statute does not provide that it survives. There's no express language in the statute about its survival after death. Am I right?
Yes, absolutely.
And what's your position about that?
My position is that under, I believe it's the Clymer case, that if there's no express provision for survivability, that the general survivorship statute would apply. That statute stands for the proposition that personal injury cases survive the death of the complainant. The statute uses the term bodily injury to describe personal injury cases, but this court in, I believe it was Whitchurch, says that the Vermont statutes abrogate the harsh common law rule that personal tort actions die with the person. Looking at what that is, in other words, broadening it beyond bodily injury, not broken bones or broken neck, but more personal tort claims, one can consult generally accepted sources of law, like the Restatement Second of Torts, that classifies wrongful confinement as a personal injury claim, that is a personal tort. And in essence, the Vermont Innocent Protection Act provides recovery for wrongful confinement. So it's our position that this is akin, if not a personal injury case that survives. I've only found one court that addressed this particular question about the survivability of an innocence claim similar to the Vermont statute, and that was the Utah case that I cited in my memorandum of Gressman, which held similarly that the claim for wrongful conviction and wrongful confinement is a personal injury claim.
But this isn't a creature of statute. It's not a, and that's what the conflict is here. You have a statute that gives you a cause of action. It's really not a common law cause of action. purely statutory. And 501, 502, and 503 sort of focus the survivability on what type of case it is. And if it's in the common law, it's in. If it's bodily injury, it's in. And some of the other specific parts that are included. So why would this be included as part of the common law when it's clearly a statutory cause?
My reading of climate says that claims that don't have a particular survivability clause, whether by common law or statute, have their survivability determined by the survival statutes. And then I'm suggesting by analogy that the cause of action created by the Innocence Protection Act is a personal tort, personal injury. And whether it's created by statute or common law, the survivability would be governed by the statute.
In spite of the fact it doesn't mention this, that this would survive, that the cause of action would survive.
Correct. What I'm suggesting, if the statute's silent, it could be interpreted either way. And that our law suggests in those situations that the general survivability statute would apply.
And then the other part of the case is obviously the issue involving the DNA test, where the statute, the statute that you originally brought, does part of it can be read into it as requiring a DNA test.
I'm sorry, I couldn't hear you.
Having a DNA test, you know, that the way you establish innocence in that cause of action is by having a DNA testing, excluding any possibility that a person committed an offense.
All right, so in 2007, when the statute was enacted, it limited innocent protection claims to DNA exonerations. In 2014, the limiting language was largely removed from the statute in every place but one. And that language, and I think it was 5592A, originally said that if someone was exonerated pursuant to subchapter 1 of this statute, which is the DNA provision, it struck the subchapter 1 language, the legislature did, and substitute this chapter. So there's some degree of ambiguity. Chapter 182 is the entire innocence rubric, which covers DNA and lots of other things. This chapter might have meant a chapter in which it arises, which would have been subchapter 2. But I think the fairest reading is that the legislature in 2014 intentionally sought to expand the claims for innocent protection eligibility by removing the specific reference to DNA throughout the statute and specifically removing the subchapter 1 language from 5592A.
Can I direct your attention to 5572A, which
Sorry, 72.
72A, a person convicted and imprisoned for a crime of which the person was exonerated pursuant to this chapter.
Right.
Isn't this chapter DNA?
Well, no, because that language is in subchapter 2 under the claim. Subchapter 1 is the DNA. In the original version of 5572, the language says pursuant to subchapter 1. That specific reference to subchapter 1, the DNA reference, was stricken in 2014 and substituted to say pursuant to this chapter. So there was a clear attempt to broaden eligibility by deleting the specific reference to subchapter 1.
In your brief, you started out by saying that the statute was not ambiguous, didn't you?
Well,
And so
yeah,
I'm wondering why we're getting into all this legislative history when your brief started out by saying this statute's not ambiguous.
and to tell you the truth, I still believe that. And I don't think I'm delusional. There is absolutely no reference to DNA exoneration in subchapter 2. It just doesn't say. There is no specific language limiting to that. The chapter says, here's what you have to allege in your complaint. Here's your burden of proof. None of those statutes limit it to DNA expressly. So my initial point of view at the trial court, my initial point of view at the brief, was say there really is no ambiguity. You can create ambiguity by this almost like a dangling participle reference to this chapter. But there's a recent 2024 case this court decided about statutory interpretation. I think it's important. And that is you have to consider the statute in its entirety. And what was the goal of the statute? The goal of the statute clearly in 2014 and 2016 was to provide compensation for people who were innocent, regardless of how that innocence is demonstrated. And I don't want anybody to forget here, if the court allows us to proceed and reverses the trial court on the 12B motion, we still bear an extraordinarily heavy burden of having to prove Stanley's innocence. And that's a critical piece of the story, too. DNA evidence is largely self-actuating. I mean, if you have a sexual assault case, an accuser says, this person forced me to have sex in the back of this truck, there were no other people around. Biological testing reveals that the biological material that was left at the scene was not that of the accused. There's nothing left to prove. He's still done. Oh, sorry.
No, you go ahead.
In 2014, in expanding claims, innocence claims beyond DNA, the legislature said, well, you know, maybe these things are going to be a little bit less clear cut. We're going to raise the burden on claimants from preponderance to clear and convincing evidence, so that you have to, if you're proving your conviction, your innocence, your conviction was vacated because of ineffective assistance, you still have to prove you're innocent. They raised the burden because they understood that some of these claims aren't going to be as self-actuated, clear-cut as DNA.
So, under your theory, anytime a person gets convicted of a crime and it goes to a Supreme Court and the court says there's not sufficient evidence and reverses the conviction, under this statute, that person can go and seek these damages. Like, where does it end?
If they were a felon and if they served, I believe it's over 6 months in jail, and they can file a claim claiming they're actually innocent. That's true. There's a summary judgment process, just like in any other civil case, that if they can't mount an adequate case, they would lose before trial. But they have an opportunity to prove their actual innocence. Actual innocence is a lot different than winning a motion on getting a reversal on suppression of a statement made to the police. I don't think you're going to see floods of actual innocence claims because you have to prove that you weren't there, that you didn't do it. And that's a really heavy burden.
Yep.
I think that's it.
Okay,
Thank you.
thanks. Hear from counsel for the appellee. Come on up, please, and introduce yourself, identify your client, then proceed.
Good morning, Your Honors. May it please the court. I'm Assistant Attorney General Hannah Yindra on behalf of the state.
Thank you.
This is a case of statutory interpretation, which turns on the cause of action provision of the Vermont Citizens Protection Act. In a threshold matter, this case is moot on the death of appellant Stanley Reynolds. The statute includes no survival clause, and it is not covered under the Vermont Survival Statute. Thus, the case is moot.
What do you say about the argument that Mr. Slay makes that Clymer directs it differently?
Well, the survival statute does preserve claims based on bodily injury. This is not a claim based on bodily injury, so as a threshold matter, it doesn't fall under that provision. However, regardless of whether or not bodily injury was involved, it's a statute. It has to have statutory survival. It's not part of the common law. As to Mr. Slay's argument that the bodily injury statute should include all personal injury tort claims or anything akin to a personal injury tort claim, there's simply no basis to support that. Personal injury claims can include bodily injuries, and that language is specifically what is preserved in the statute. The statute doesn't preserve all types of personal injury claims.
Well, we did decide, I think there's a case, Cooling, that breach of fiduciary duty services, breach of fiduciary duty survives. That
Yeah,
hardly seems to expand the scope.
in some ways, it does expand what is explicitly identified in the other provision regarding estate claims, personal real estate claims. And I think in that case, the court decided that because fiduciary duty was part and parcel with real property claims, it really traveled with the estate and it made sense to preserve that claim. This is really not related to the personal estate or real property in any way.
I found a case called Administrator of Whitcomb versus Cook. It's from 1866, but it's a Vermont case. And in that case, I say we said, none of us were around in 1866, but that an action to recover damages for an unlawful arrest or imprisonment survived the death of the party injured, it being regarded as an action to recover damages for a bodily hurt or injury. Does that apply?
I'm not sure off the top of my head, but I want to say that the survival statute was probably passed after that case. And so that's going to,
But it uses the same language.
it does use the same language. I think as a general matter, false imprisonment claims are quite commonly understood to abate with the death of the claimant. And I would put that more akin to this than to that case, but admittedly, I haven't looked at that case from the 1800s.
So so what the cause of action is here, it's a statutory cause of action without a survival statute, but there is an underlying common law cause of action as outlined by Justice Carroll.
Well, there can, in some sense, be an underlying common law cause of action, but there must be a cause of action to sue the state. Here, you must waive sovereign immunity to sue the state. The statute allows you to do that. Common law only allows you to do that in some regards through like a 1983 claim or something akin to that. So really, it's quite limited in your ability to use common law to sue the state. And this simply isn't on the basis of any sort of common law claim. This is for compensation. It's not for bodily injury damages. If there's no more questions on mootness, I'll move on to the heart of this case, which is statutory interpretation. And it should be resolved on the plain language of the statute. Here we have cause of action provision. As I was saying, to sue the state, you need two things. You need a cause of action and you need an express waiver of sovereign immunity. This is what the cause of action provision provides. It is the express waiver providing a certain class of claimants with a cause of action to sue the state. Appellant simply was not exonerated pursuant to the statute, which is the requirement. Appellant's argument that the pleading standard is sufficient doesn't offer an alternative interpretation. It merely asks the court to read the cause of action provision out of the statute entirely, including the notice provision and the statute of limitations provision, which must also be read out in order to allow appellant's cause of action to proceed.
What was the legislative change intended to do, the change in language?
Well, when this court interprets statutes, it looks primarily to the text. There's no ambiguity in the text, which means that we must give the plain meaning its effect. However, although no one argues that the language is ambiguous, if this court wants to look to legislative history to support the legislative intent, there is an amendment history. That legislative history is entirely inconclusive and does not support what appellant argues it supports, which is that the legislature intended to remove any limitation on who has a cause of action under this statute. That is what the court must decide in order to provide appellant with a cause of action here. That would put this statute far outside the norm for other wrongful conviction claims, which often put a limit on who has a cause of action to sue.
Is the statute ambiguous regarding the need for a DNA test?
No, the statute requires that appellant be exonerated pursuant to the statute. The only way for an exoneration pursuant to the statute as the statute currently exists is through subchapter 1 in the DNA testing.
So you have to have, but what if by other means they could prove that an absolute 100% certainty that the defendant did not commit the offense? I mean, science is evolving. There could be a different test. There could be new methods to make those determinations.
If the legislature seeks to provide that kind of person with a cause of action, they can change the language of the statute to do that. But as the statute exists, it's quite clear, it's quite consistent across provisions, and it has certain requirements. There's just no basis to interpret the language differently. In order to hold for appellant here, the court is going to be faced with several problems. It's going to have to look at sparse legislative history to contradict the plain meaning of the text. It's going to have to rewrite several provisions of the statute, including the notice provision, the statute of limitation provision, the cause of action provision. It's going to have to essentially legislate to decide who should have a cause of action under this statute. This isn't a case between two potential interpretations that the court can decide between. This is a case of either effectuate the language the statute has or decide on a completely new interpretation of the statute with new policy, a new understanding of what the legislature wanted to do here. There's no easy way to simply side with appellant. The court will be put in the position of legislating and choosing who has a right to sue under this statute. If that is all, we respectfully request that the court affirm. Thank you.
All right, thank you. Does the appellant have time?
Appellant has 2 minutes and 34 seconds remaining.
Counsel?
Mr. Slade, before you get to the points you'd like to make, can I ask you a question about the limitations period and the notice of right of action, both of which appear to refer to subchapter 1 of this chapter? So what is the statute of limitations for your claim that is not a subchapter 1 claim?
I don't know the answer to that question, Your Honor. I'm sorry to say that. If it's I think, the problem is the legislature went in to adjust the statute twice, once in 2014, one 2016. It's clear they meant to expand eligibility. They left some things, I think, undone. And I don't know if I can say anything better than that.
Thank you.
But looking at the statutory scheme as a whole, and the legislature's successive intention to expand eligibility, foreclosing the claim because of this incomplete amendment, I think would be contrary to the legislature intent. The one thing I did want to address is the waiver of sovereign immunity argument that my colleague has raised. One of the cases they cite, College Savings Bank, says that waiver has to be clear, but it can be implied. It doesn't require capital letters on the top of every statute says this is a deliberate waiver of sovereign immunity. In this particular case, the legislature created a cause of action and it created limitations on damages. They listed the types of things you can recover. Unlike, for example, the Depot Square case where you decided that because the statute didn't say that it provided for attorney's fees, that the state hadn't waived sovereign immunity for attorney's fees. The statute is very explicit in listing what it comes to.
Okay. Thank you both. Please call a conclusion.